Welcome to Law Sessions. I am Jennifer Housen. In this law session, we will explore the structure of government in the UK, and we will also look at the House of Commons and the House of Lords. We will touch on things like collective ministerial responsibility and individual ministerial responsibility. So the whole idea of this particular law session, of course, is to look at how the framework of government is in the UK, and that's using government in its legal sense, which is, of course, central government being the Prime Minister and the Cabinet. And we will also look at it from the context of Parliament and, of course, the government in Parliament, and we will look at the House of Lords. And that is what we'll more or less cover over the next hour or so. Now, what I want us to start off with is looking at government, the structure of government, which takes us to central government, and in particular, looking at the framework as it relates to the Prime Minister and the Prime Minister's Cabinet. Now, when you look at Britain, it is a constitutional monarchy, and the government is known as Her Majesty's government. Now, the sovereign must be seen to be above party politics. She needs to be able to deal with prime ministers from different political parties, and she should be able to be seen to be more or less politically neutral at all times. Now, the Prime Minister does have a weekly audience with the sovereign, and he more or less hands to her, or she receives cabinet documents. And her role, as we have seen in previous law sessions, is more or less as described by Walter Bagehot, as comprising the right to advise, the right to encourage, and the right, of course, to warn the government. But it's certainly not for the monarchy to say, well, this is the way to go. One of the advantages of having this kind of monarchy, of course, is that it has the continuity in that from successive governments, and certainly when one looks at the current Queen, we see that she has over 60 years of experience in this sort of thing, and it does show a degree of continuity. So we see that the monarch appoints the Prime Minister, and of course, following the Prime Minister's advice, she appoints all the ministers of the Crown. Now, subject, of course, to recent legislation, we see that there was the power to summon Parliament, and although we see that there was a former prerogative power to dissolve Parliament, the regulation is now under the Fixed Term Parliaments Act of 2011. Now, as it relates to the Crown, of course, gives the royal assent to bills, and we see that there are various other prerogative powers, as has been mentioned in previous law sessions. And what we have more recently is that in 2012, the government has, of course, announced legislation or intended legislation whereby succession to the throne will be amended, because certainly on the wave of this Catherine, we have William and Catherine getting married, and there's this concern that if they have a daughter as their first child, that child, of course, would not succeed to the crown if, for example, their second child is a boy. So what we're seeing is that this male line of succession, they're looking to revamp that, and seeing that succession would not be tied to the male gender. What we also see in contemporary society, of course, is this intention to remove discrimination against Roman Catholics succeeding to the throne. And one of the changes we have also seen as well is the way in which the sovereign's official duties are funded. Now, if you're looking, for example, at any question in relation to the sovereign, and in particular changes to the sovereign, we do see that the constitutional nature of the monarchy certainly remains, but what you can see is that there have been some contemporary changes, and certainly from funding through to succession rights, there have been some degree of changes. Now, as we look at the framework of government, as I say, we start with the cabinet, the Prime Minister and the cabinet. There's also the Privy Council. Now, the mistake, of course, for some law students is to think that the Privy Council just relates to that branch where there is an appeal, for example, and it goes to the Privy Council. That is only but one part of the Privy Council, and that part is called the Judicial Committee of the Privy Council. So most Commonwealth countries still have the Privy Council, the Judicial Committee of the Privy Council, as their final court of appeal. But in the context of the structure of government, the term Privy Council has its origins, of course, in the group comprising the sovereign's closest advisors. And what we see is that the Privy Council is sort of the predecessor to the cabinet, and the membership does fluctuate. And what it comprises is the Queen, prime ministers, all cabinet ministers, all past and present prime ministers and cabinet ministers. We see it includes ambassadors, senior judges, heads of the opposition parties, and of course there are certain leading figures from the Commonwealth. So if you are certainly watching this outside of the UK, it may be that if you're in a Commonwealth country, there may be certain ambassadors and senior politicians in your own country who are a member of the Privy Council. And the idea is that through orders in council, the Privy Council gives effect to decisions made by the cabinet under statute or under the royal prerogative. There is an oath of secrecy, and certainly the Privy Council is there as a group of advisors to the Queen, as it were. And a lot of times when things have been taken, for example, when you look at prerogative powers being exercised, it will then, of course, go through for example, an order in council from the Privy Council. Now, the office of the Prime Minister, as we have seen when we looked at conventions, it is established via convention rather than law. And historically, when you look at the growth in cabinet government, a need arose for there to be a principal minister to advise the crown. And indeed, when we look at the role of the Prime Minister, it is defined as, or it is said to be inter pares, which means first among equals. Well, although the breadth of the Prime Minister's powers is such, there may be a suggestion that the Prime Minister is no more first among equals as above those below him or her, because the breadth of the Prime Minister power seems broader than just somebody who is equal with other members of the cabinet. Now, the Prime Minister is the head of the political party that wins the largest number of seats at a general election, and also the Prime Minister is just a regular MP, and he does have his or her own constituency. Now, he or she chooses who will fill ministerial posts, and certainly when you look at the reorganization of government departments, again, the Prime Minister oversees that. Certainly, the Prime Minister may also appoint or dismiss a minister in the name of the Crown. And when one looks at cabinet and certainly ministerial responsibility, we see that the cabinet represents the center of government. This is where policy emanates. And by and large, albeit you have the parliamentary framework where the cabinet sits in with parliament, we see that the policy is driven from here. Now, the cabinet's constitutional role is to provide confidential advice to the sovereign, and the cabinet, of course, meets in a weekly discussion. They decide and endorse government policy, and certainly they are, by all intents and purposes, a law unto themselves at times. Now, there are two concepts which you need to be very aware of and at least know the background and framework, and that's the concept of ministerial responsibility. Now, when you look at collective ministerial responsibility, for example, it requires that discussions remain confidential and that once decisions are reached, the cabinet stands united on the decision. Now, the idea, of course, is that if there is a cabinet decision taken, it can't be that a cabinet minister comes out and say, well, I wasn't too happy about it, but that's the cabinet and they have gone with it. There must be, but for all intents and purposes, a united front. Now, when you look at the constitutional conventions as it relates to ministerial responsibility, again, it is a convention. It is not legally enforceable. And when you look at, as I say, the collective ministerial responsibility, it's about actively supporting cabinet decisions. And the government, by and large, the government, the cabinet, must actively support the decisions. Again, it can't be that individual members make a decision that they are not happy with policy. Indeed, when one looks at even the Iraq War and we see the decision taken then, here we saw that there were some senior government ministers who felt their positions untenable precisely because they did not agree with the policy. So the idea is that if you're in opposition to an executive action and it is so strong that you simply cannot support it, then the idea is that you ought to resign. You act as a whole when it comes to collective ministerial responsibility. Confidences are kept, and as it relates to disagreements, it is not for any individual minister to make the decision that he or she is not happy. Now, by and large, collective ministerial responsibility works if you're looking, for example, at a single party government in power. What we have seen, though, in particular, when we've seen this new coalition government in the UK coming on board in 2010, it has been that the doctrine has become somewhat strained because, of course, there are policy differences between the political parties. So when you look at collective ministerial responsibility, which says that you need to stand behind a particular decision made, we see that sometimes it is difficult, for example, for the liberal Democrats who are following or came on board on a mandate of a particular path they want to follow. It may be completely different from the path that the conservative government is going down. Now, the most recent, of course, and obvious example of what appears to be a breakdown in collective ministerial responsibility has been this whole stance taken over the European Union. Because in December 2011, the Prime Minister David Cameron had attended an emergency EU summit, and at that meeting, where there was an agreement between all the 27 member states of the EU discussing stabilizing the Eurozone, well, they had expected that agreement would have been reached in this regard. Now, the Prime Minister, of course, felt he was unable to support the proposed new treaty, and for the first time since Britain had joined the EU, Britain exercised the right of veto. Now, the Deputy Prime Minister, who's the Lib Dem head Nick Clegg, declared that the decision was, of course, bad for Britain. And he then, by doing that and by making that remark, put himself in direct opposition to the Prime Minister. Now, this is a policy issue. And as I say, collective ministerial responsibility would have required for him to stand behind the Prime Minister. Now, notwithstanding that conflict, what we see is both the Prime Minister and Nick Clegg emphasizing that the coalition government would remain. It remained intact, and as far as they were concerned, collective ministerial responsibility was not compromised. So, by way of recap, when you look at collective ministerial responsibility, it requires a united front from the cabinet. And if it is that a cabinet minister, feels that he cannot stand behind it, then his position, by and large, becomes untenable. That is where we see collective ministerial responsibility going. What about individual ministerial responsibility? Well, individual ministerial responsibility looks at a minister. So this is, of course, a cabinet minister's looks at his responsibility as it relates to his personal approach. And personal approach relates to two things. The first is a minister is required to conduct himself or herself in such a manner as not to cause embarrassment to the government or to the political party. So the first thing is how they deal with their private life. The second aspect, of course, is responsibility for the conduct of their departments. Now, with regard to their own actions, a minister may need to resign if it is that his behavior falls in a situation where it amounts to conduct unbefitting a minister of the crown. Now, in practice, this will depend on the circumstances of the conduct, and more often than not, what you see happening is whether that behavior becomes public and whether there is some adverse media reactions. And sometimes what you see is that ministers have held on and waited before they resigned just to sort of gauge public opinion. And by and large, there have been various reasons that we've seen, for example, resignations. It's been about extramarital affairs, it's been about personal conduct, and it generally, as I say, depends on whether or not a person, a cabinet minister, has the backing of his party. Now, there have been some recent situations of government ministers that goes to individual ministerial responsibility. We're going to take a short break, and as we come back, we're going to continue looking at individual ministerial responsibility as it relates to the government. And immediately after this break, we will continue, and we will also carry on and look at the House of Commons as well.